Hi friends, welcome to the channel. This is your Govindraj. Thank you very much for watching my previous videos and also staying in my channel, which is membership channel. Today we are going to talk about an important topic. See, if you look at the employment contracts, many of the companies practice that there is a minimum service requirement criteria is put into the contract. Either it is available or incorporated into the employment contract, which is appointment letter, or many of the companies also introduce certain kind of employment bonds or service agreements or service bond you can call, where when the employee joins, he is required to serve for a minimum period of time, so that the employer can retain him and reduce its attrition and also contribute to the for his clients. So this is the set practice, and some companies also depute for qualitative training, where they get equipped with more and more skills and competencies. In order to utilize these competencies and skills, the employer puts a condition that you have to work for a minimum period of service after certain period of time, or after the training, or even in the case of giving employment, this putting this minimum service criteria has been made mandatory either by employment contract or in the separate agreement. So far what we used to see is this is a one-sided contract, and this is not going to be valid in the eye of law unless the agreement is worded, or agreement is put in two-sided contract with proper consideration. Now if you look at the society, the needs of the society are changing, and the needs of the people are changing, and there is a more and more requirement of competition is coming up. So therefore the employers have to considering these things, they have to cope up and compete with their markets. Therefore they are putting these kind of conditions. Now recently the apex court got into this topic and also understood the changing requirement of the society, and held that these contracts of restrictive covenants, we call it as, they are valid if they are reasonably placed. So that is the point of subject for today. We are going to talk about it. Let me take you through, friends. Now these employment bonds which restricts the employee from leaving the company within certain period is actually stated as restrictive covenant in the agreement. So this may also provide certain liquidated damages in case of breach. Suppose if employee is unable to complete this minimum period of service, then he is required to pay certain compensation, or we call it as damage in the contract law. So these are restrictive covenants in the agreement, and these are held to be violative of the provisions of the constitution, and also certain provisions of the Indian Contract Act 1872. So now the situation has changed, and in order to understand this topic, we need certain key provisions of law, especially under Indian Contract Act 1872, and also certain provisions of the constitution, and main particularly article 14. This talks about equality before law. So as per this, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So when there is unequal parties, then this has to be managed properly. And more particularly article 19(1)(g), protection of certain rights regarding freedom of speech, and 19(1)(g) specifically talks about all citizens shall have the right to practice any profession or to carry on any occupation, trade or business. When the employee leaves and goes another company, then that should not be restricted with any restrictive covenant. So that is the objective. And section 23 of Indian Contract Act 1872 talks about what consideration and objects are lawful and what not. And mainly with related to these restrictive covenants, we have to talk about the consideration or object of an agreement is lawful unless the court regards it as immoral or opposed to public policy. So these restrictive covenants which are placed by the employer are actually regarded as one-sided and with unfair treatment, because he will be at the superior capacity, and when he is imposing on the employee who is willing to work, or who is a requirement of job, then he signs everything. So therefore when employer uses this opportunity and exploits the employees, that is called as opposed to public policy. Now this restrictive covenant when it is put reasonably, whether it is opposed to public policy or not is important. Now if you look at under normal circumstances, if contract are unconscionable, unfair, unreasonable and injurious to public interest, they shall be deemed void in law, being opposed to public policy. So this is so held by the apex court in the case of Transport Corporation versus Brojonath Ganguly in 1986. So therefore, if there are unreasonable provisions in the employment contract which is unfair, then those contracts are not valid in the eye of law. Now, what is this public policy? Actually, if you look at the Constitution or the Indian Contract Act 1872, has not defined what is public policy. So, therefore, you have to understand, and this public policy also changes from time to time because considering the needs of the society, what is publicly is good is also changing from time to time. But what you can understand considering the circumstances is what is just fair and reasonable for that situation is called as public policy. And in the case of employment contract, misuse of unequal status of a party by one-sided restrictive covenant can also be regarded as opposed to public policy. And considering these interpretation and these restrictive covenants where there is an unfair treatment to the employee, they are held to be not valid in the eye of law. But however, recently, the apex court in the case of Icha Bank, especially in May 2025, considering the changing needs of the society and business, held that the restrictive covenant prescribing a minimum term cannot be said to be unconscionable, unfair, or unreasonable, and thereby in contravention of public policy, more particularly when minimum service condition is incorporated to reduce attrition and improve the service of the employer. So this is got a valid point, and it was so held by the apex court recently in the Vijaya Bank case. So therefore, these restrictive covenants where there is a reasonable restriction or reasonable minimum period of service is put in, they are not held to be opposed to public policy. And let us look at another important section of Indian Contract Act 1872, which was also used to hold that restrictive covenants are not valid in the law. So that is section 27 of the Indian Contract Act 1872, and this talks about agreement in restraint of trade. Every agreement which restrains a person from exercising a lawful profession, trade, or business of any kind is to that extent void. So, if you are restricting someone to go and join any other company at his choice, then such a restrictive covenant can also be held to be not valid in the eye of law. But however, in the 1981 and in 1967, the apex court has already made this point very clearly that negative covenants or negative terms or negative agreements operative during the period of the contract of employment. You see, if any negative covenant operates during the period of contract of employment, when the employee is bound to serve his employer exclusively or generally, it is not regarded as restraint of trade, and therefore do not fall under section 27 of the Contract Act, and such terms of employment cannot be regarded as restraint of trade. And very recently in the same apex court in the Vijaya Bank case held that the object of the restrictive covenant was in furtherance of the employment contract and not to restrain future employment. Hence, it cannot be said to be violative of section 27 of the Contract Act. So therefore, when any restrictive covenant is operating during the employment subsistence, then such a term cannot be regarded as restraint of trade. So this is the stand of the apex court recently, and also going by the previous judicial trend. Now let me give you certain conclusions. See, first thing is minimum service criteria incorporated in the contract employment or separate bond is not opposed to public policy or restraint of trade when the service criteria, minimum service criteria has to be reasonable with an objective to reduce attrition and improve service of the establishment of the clients. And the liquidated damages in case of such a breach should also be reasonable considering the compensation and other benefits offered to the employee. So this is one of the things. So since it is valid in the eye of law, you cannot go and put whatever the conditions you want. See, if they are unreasonable and unfair, they can be also held to be violative of legal principles. And the third condition is the restrictive covenant should apply during the tenure of the service. If any term which restrict is employments after the separation of the contract, such a term is which is called as restrictive covenant is not valid in the eye of law. And finally, friends, as far as possible, your contracts have to be two-sided, properly worded, and drafted with utmost care. So, when you are drafting all these things, you have to take multiple factors into consideration and draft your employment contracts. And in case you want to talk to me for any of these topics, let me know. So, I will be available for your discussion. So, thank you, friends, for watching this video so far, and I'm sure this has enhanced your knowledge and validated your knowledge so far. And I'm going to come up with more and more innovative topics and more constant news on these topics. And stay tuned. Until then, I'm going to sign off and see you soon in the next video, friends. Thank you very much.